and timekeeper for this round. Judges, the following is the time allocation for each team. The time allocation for petitioners with team code CNL 22. Speaker 1 is 21 minutes. Speaker 2 is 22 minutes. And they have reserved 3 minutes for rebuttals. The time allocation for the respondents with team code CNL 40. Speaker 1 is 22 minutes. Speaker 2 is 18 minutes. And they have reserved 5 minutes for Sir rebuttal. We shall begin the round now after taking the permission of the judges. Judges, shall we begin the round?
Yes, please.
Yes.
The council seeks permission to submit the compendium. Court master.
So this is a petitioner one. Speaker one, Kushbu. Correct?
Council seeks permission to begin.
You have to be a little louder.
Or you can take the mic nearer. Yeah.
It's my honor to appear before this honorable court. Is it audible?
Yes.
Is it audible?
Still up.
It's my honor to appear before this honorable court. Good morning. The council seeks permission to address this bench collectively as the lordship.
Yes, please.
Much obliged. Your lordship, the council is here before this honorable court under Article 32 on behalf of petitioners, Mr. Aman and others. The council would like to state beforehand that council 1 would be dealing with issue number 1 and 2, and my co-counsel would be dealing with issue number 3 and 4. The council would like to ask if the lordships are well versed with the facts. The council seeks permission to proceed with the issue submissions.
Yes, please.
Much obliged, your lordship. Proceeding with the issue submissions, the issues raised herein are the provisions of the said act, which does not take consent under section 6 and allied provisions, violate Article 21, right to privacy. Secondly, the provision of bank account details does not constitute a legitimate purpose under section 7 and allied provisions as stated in the said act. Thirdly, the provisions that provide immunity to the central government under section 35 on account of good faith violates petitioner's right to seek remedy. And fourthly, the exemption of certain data fiduciaries under section 17, subsection 5 by means of notification is an arbitrary exercise of discretion and thus violative of Article 14 of Constitution of India. The lordship, the council seeks permission to proceed with the first issue.
Yeah, proceed.
Much obliged, your lordship.
You are appearing for whom?
Lordship, we are
petitioners.
appearing for
Petitioners.
petitioners.
All right.
Petitioners, we have 2 councils, but the council number
Mr.
1
Aman and others, lordship.
she will be addressing issue number 1 and 2.
Yes.
Council seeks permission to proceed.
Yes, please.
Much obliged, your lordship. Proceeding with the first issue.
Don't waste time again asking for permission. You have got the full permission. Go ahead.
Certainly, lordship. It is humbly submitted that the petitioners that the provision of the said act, it is section 4, subsection 1, clause B. If the lordships are kind enough to refer to section 4, subsection 1, clause B.
Yes, please.
If the lordships are with me, your lordship, section 4, subsection 1, clause B gives power to collect data in 2 ways. One by taking consent and one by not taking consent. Now, the not taking consent falls within section 4, subsection 1, clause B, that is for certain legitimate uses. Now, certain legitimate uses, as per the definition clause, has been defined under section 7, that of the said act. Under section 7, we don't require at all consent. And herein we are challenging that not taking consent and processing data violates right to privacy. Therefore, lordship, my submissions would be based on these 3 premises that has been laid down in case Putuswamy versus Union of India. Before that, if the lordships are kind enough to refer to flag 4 of compendium. If the lordships are with me. Lordship, the relevant mark portion, the next page says that what is informational privacy, your lordship? Informational privacy means an individual have
Only 2 sets. You can check this. No, you can check this. We'll share with this.
the council seeks permission to proceed. Your Lordship, information privacy means individual has control over dissemination of information. It means I, as an individual, will decide how my data would be taken. So any infringement on that part would be lead to violation of privacy, considering the fact that consent is considered as the most integral aspect of collection of data, Your Lordship. Now, the Lordships are with me. The Council seeks permission if the Lordship would refer to flag 8 of compendium.
Flag 8. Yes, go ahead.
Your Lordship, I plead my ignorance. It's page number. It's page number 2 of compendium. I plead my ignorance for the same. It states that their privacy could be taken. It is not an absolute right.
She said about 8, no? Flag 8.
No,
Yes, she wants to go for page number 2. Oh, yeah, all right. Okay,
Your
go ahead.
Lordship, privacy could be taken if it conforms to these 3 tests. And herein my contentions that it does not conform to the proportionality, which is one of the tests. We are not denying the fact that there was a legality, which means there was an existence of the law. We are not denying the fact that there was a legitimate aim, but we are denying with the fact that there was no proportionality. Your Lordship, if they're kind enough to refer to page number 8,
Yes, page number 8.
compendium, flag
Yes.
8.
Page 10. Go ahead.
Your Lordship, it states that there are 4 measures under proportionality. That is, there had to be legitimate goal, there had to be suitability, there had to be necessity, and there had to be balanced test. I'll explain what does it mean, and these are the final 3 submissions, which means that there had to be suitable means to achieve the state aim to infringe privacy. Secondly, that by not taking consent. Secondly, that there had to be least restrictive remedy, or there had to be an alternative efficacious remedy not available. Fourth, and the last submission is that the means should not create a disproportionate impact on the data principles herein. These are my 3 submissions.
Now, your contention is that this is violative of Article 21. Is that
Certainly, Your
correct?
Lordship, right to privacy.
Right to privacy is part of Article 21.
Certainly, Your Lordship.
Now, how is this question of consent at all relevant? Assuming that the consent conforms to all the requirements of the law, what you just now mentioned, proportionality, informed consent, everything. Still, can a fundamental right in Article 21 be waived?
Your Lordship, a fundamental.
Under Article 21, can it be waived?
Your Lordship, Article 21 is not right to
No,
privacy is not.
Please understand. We'll reframe it.
Certainly, Your Lordship.
Would it be an implied consent?
Your Lordship, if the Lordship are kind enough to refer to more proposition in B.R. Shri Krishna report, please.
I just want to add to what my Lord said.
Certainly, Lordship.
Even if it is express consent,
Certainly, Lordship.
can you waive a fundamental right guaranteed under Article 21? Now, let me assume that it is an express consent. I give something in writing saying that my right to privacy regarding my financial affairs, I hereby waive, I give you full permission to use my financial data for any purpose you want. Is that consent valid under Article 21? What is your view?
Your Lordship, it is not valid. First of all, if as per
That's all.
section.
Okay.
Proceeding with my first, if the Lordship are
No,
convinced.
see, the question that we are asking is, are you saying that if the consent is given, this is fine?
Without it, certainly, Your Lordship.
No, see, you're raising 2 issues. One is that there is no consent,
Certainly, Your Lordship.
and
Which leads to violation of
that
privacy.
does it mean that if you are given a consent, then it is fine?
Your Lordship, if it is conforming to fair, just and
No,
reasonable.
I write
No,
it
no,
to
no,
you on a
please.
paper that you kill me. Will you kill me?
Your Lordship,
Exactly.
illegal contracts are not enforceable in law.
Exactly. Now, let us assume that the consent given is fair, just, and equitable. It is in writing. It is express. Still, would such a consent be acceptable if it violates the right under Article 21?
Your Lordship, Article 21 is not absolute in nature. Therefore, it cannot be abided in all the situations. But herein, my test says that we are the
No,
respondents are
forget
not
your
able to
case.
comply.
Forget your case. We want to know the general proposition. You have come to the point. Little more.
Lordship, it is not absolute in nature, Your Lordship. We conform to the point and we agree that it is not absolute in nature. But it doesn't mean that even
No,
if it is not
please,
absolute
please.
in nature, it could be
See, the
taken.
question is, can there be a waiver of a fundamental right by a contract? That's all the simple
That's all the
point.
question we are asking you. By your right, there can be I quite see your point that Article 21 right is not absolute. Every right is subject to reasonable restriction. No
Certainly,
doubt
Lordship.
about what you're saying. Now, that restriction can be imposed by a statute. Can it be reduced by a consent in writing as if by a contract of parties? That's the question.
Certainly not, Your Lordship. It cannot be waived off.
Right. Okay. Understood.
Go ahead.
Now, proceeding with the three sub premises which I mentioned, if the Lordship wants me to repeat, I'll repeat the same.
No need to. Go ahead. Go ahead.
Certainly, Lordship. For proceeding with the first submission, that there was no suitable means to achieve the state aim, or there was no rational nexus. Your Lordship, the primary contention relies on, if the Lordships are kind enough to refer to Section 4, Section 7, subsection C and D. Lordship, due to paucity of time, I'll explain without reading in
Yes, go ahead.
totality. Your Lordship, it gives power to state or any of its instrumentality. The focus on the word is any of its instrumentality to perform any function or to perform any obligation. Under these conditions, there is no requirement of consent, which means, Your Lordship, after Ajay Hasia case, Ajay Hasia versus Khalid Mujib, which I cited even in the compendium, and now any corporation could come up and say that I am performing a public function, therefore I am state or therefore I am an instrumentality. Now, complying with these provisions, I'll give a very simple example, Your Lordship. Consider that there are two electricity boards. There's one electricity board here in Karnataka, and therefore another corporation come up and said, I'm also performing a public function, therefore I fall within the instrumentality. Now, as a data principle, I have the option, I can seek my electricity from A or B, either B. Now, by merely being an instrumentality or data fiduciary in this case, they can take all sorts of data, Your Lordship, which means that even if I'm not using their services of electricity, they have power under this provision to take my data without consent, which is even not required in the case. Therefore, it is not a suitable means to achieve the state aim, Lordship. That is my contention here.
Now, I have a question for you here. Now, the company in question here
Certainly, Lordship.
is not similar to electricity board, because electricity board is constituted under a statute. Now, this is a company.
Your Lordship, the example was pertaining to an instrumentality, means any corporation who provides services of an electricity.
No, maybe government is involved, government.
Maybe 100% shareholder.
That's
But
not-
still, it could be instrumentality of the state for the purpose of Article 12.
Certainly, Lordship.
But is it the same as government?
Your Lordship, as per this provision, it is same functioning, same.
Any
as
answer you give will also affect her on
uh,
the other issue.
Certainly, Your Lordship, as per this section C and D, it means that any state or instrumentality can perform a public function and can process the data without seeking consent, which means here in this condition, it is same. Lordship, I would reserve the same for my
No, you refer to, I'm asking this question because you refer to Ajay Hasia.
Certainly, Your Lordship.
Now, Ajay Hasia was simply a case as to whether it is an instrumentality of the state.
Certainly, Your Lordship.
That is for the purpose of Article 12.
Certainly, Your Lordship.
Article 12 of the Constitution.
Certainly, Lordship.
Right
Yes.
from Rajappa's case.
Yes.
Certainly,
Now, the question I'm asking you is only simple. Is a company like the company in question, maybe it is 100% owned by the state, does it become the state?
Your Lordship, constitutionally speaking, the powers given to state.
No, to
are
take the advantage under the section 7A to I. That's the point.
Your Lordship,
You should get that point.
Your Lordship, as per the DPTP Act.
Since you said that, for paucity of time, 7, you don't want to go in elaboration. We were making the things simple to you to tell me whether it comes under A to I, 7.
Certainly, Lordship, under section 2ZB, it stated state means the state as defined under Article 12 of Constitution. Article 12 also defines other authorities, and other authorities have been defined under Ajay Hasia. Therefore, it is same in pertinent to this case, Your
Whether
Lordship.
company, petitioner,
Has the power-
this company is one such is the question.
Certainly, Lordship, it is one such. Therefore, I am relying on it, and this is a question of substantial question of general importance. Therefore, we are here challenging the entire constitutionality and not dealing with the pertinent section 7B.
We are not on the jurisdiction. We are not on the jurisdiction. Jurisdiction is there.
Certainly, Lordship.
Your petition is admitted. You are in the final hearing.
Certainly, Lordship.
And you are claiming under section 7C, right?
These are the exemplars of the
No,
word.
section 7C, the instrumentality that you are using in 7C.
Certainly, Lordship.
7C.
7C, what does it say?
That
It says it can take information from anybody for the purpose of sovereignty and integrity of India, right?
Or, your lordship, it is mentioning or, even for performing.
No,
of
look at,
public-
read section 7C.
Sorry, your lordship, for the performance by the state or any of its instrumentality of any function under any law for the time being in force in India or in the interest of sovereignty and integrity of India.
So it has inbuilt mechanism of restrictions and redressal. What is your issue in this?
Your lordship, my issue is that it is not the suitable means. When we're reading or, it means that first part is still applicable. You don't need to abide by second part. And when you're abiding by the first part and giving such an instrumentality, whether I'm availing the service or not, still they have the right to process my data.
Instrumentality can avail the service only for the purpose of or in the interest of the sovereignty and integrity of India.
Data principles can avail the service and data fiduciary do collect the data. Data fiduciary herein are instrumentalities.
Correct.
Certainly, lordship.
Object is that
What
data
is the
protection
purpose?
is that.
What is the purpose of collecting this information?
Your lordship, that is my contention that
No, it is very clear.
Lordship,
It
as
is
a
only
way-
for sovereignty and integrity of India.
Your lordship, when it is stating or, we cannot read in totality.
Read.
In your lordship, it states that for the
Yes.
performance by the state.
Yes, yes.
I don't see. See, the performance by the state or any of its instrumentality of any function under any law. That means
Certainly,
the
lordship.
instrumentality functioning under any law.
Certainly, lordship.
So therefore, it is not saying for any purpose you are going to collect.
Certainly,
You are
lordship.
collecting
For a
information
definite purpose.
only for two different purposes.
That was my contention was lordship. Even electricity providing, just an example I was
Forget that
That is-
electricity,
See,
electricity
even
example,
electricity
give it up.
department can collect only in the question of sovereignty and integrity.
Your lordship, it cannot be collected in sovereignty, even if it is performing a public function. That what is the
No,
or
I don't
word
think
suggests,
so.
your
I don't
lordship.
think so. It look like misreading.
Your lordship, this gives unfettered power. When we
All
read
right.
it that,
Go ahead. I think you should go
Sorry,
to the
Lordship.
next point.
your lordship,
You are losing time.
Certainly, Lordship, I'll proceed. The second point is it is not the least restrictive remedy, Your Lordship. Firstly, how I'll contend is there is a difference between public data and private data. Public data is government, it is available on government domains. And second is a private data, which means any sort of sensitive information, including financial data. This section 7 does not bifurcate between whether they would collect private data or public data. It means that the precaution is more than the precaution taken is less than the harm caused, Your Lordship. Giving such this lack of this bifurcation poses a serious threat of data leakage and misuse. Therefore, it is not the least restrictive remedy. And here the other contention is that we have an alternative efficacious remedy. What is the alternative efficacious remedy? The Lordship are kind enough to refer to page 22 of compendium of B.R. Shri Krishna report. The Lordships are with me.
Yes.
The Lordship, it states that the contention raised by respondents are that we cannot collect data in real time, but it is difficult to collect in data in real time. But Lordship, the B.R. Shri Krishna report itself suggests an alternative efficacious remedy. That is, what you do is you make a consent dashboard, which means data fiduciaries will appoint somebody, they'll make a dashboard, and it will collect the data in real time, which means there's no necessity that you don't need to collect data without by consent. Secondly, Lordship, first, this is one of the alternatives.
I want to interrupt you for a minute. You made a distinction. You used two terms, private data
Certainly, Lordship.
and public data.
Certainly, Lordship.
What is the distinction?
Lots of public data is certainly, which means that it is available on public domain, government domain platforms, and which it is essentially, as it is available on government domain platforms, it doesn't require that much scrutinization, that much security pertaining to sensitive data which falls within private data.
Focus with appendix 2, no, straight away come to their web page and then say where they have violated.
Your Lordship,
Companies dashboard.
Sorry,
It is in the form of appendix 2.
Your
You
Lordship.
can go there and then point out this
Sorry.
was not required and they have collected this.
Certainly, Lordship, my remedy was more or less, I'll just delve into that.
Straight away.
Okay,
Straight away there.
Certainly,
They have
Lordship.
said we use the information collected to
Lordship.
receive for such and such things.
The Lordship, they are kind enough to refer to appendix 2. The Lordship, the third line, if the Lordships are with me.
You go ahead, no? I have gone through
Yeah.
it through and
I
through
plead my
every
ignorance
letter.
I plead my ignorance. The Lordship, it states that we collect the data. Now, Lordship, as per section 2, subsection D, it states the ways of processing of data, which means there is a clear cut as per section 2, subsection D. There are ways of processing of data, which includes the element of processing of data, which categorize, collect, and store as different, Your Lordship. It is not
Candidate,
same in nature.
simple. Mr. Counsel, only one point.
Certainly, Lordship.
From this, what were you required to give
Lordship,
and what was not told, what was hidden and how they have misused it. Come to that point so
Lordship-
that you can address the issue number 1. You have to address issue number 2 also. Time is running
Your
out.
Lordship, they have not mentioned bank account details explicitly in the appendix 2. That is not mentioned, and that is not taking of any sort of consent. Explicit is not at all there, Your Lordship. That is my contention as per section.
I want to
1.
ask you another question.
Certainly, Your Lordship.
Now, is the right to privacy so far as personal data is concerned absolute?
Personal data as in, Your Lordship?
As opposed to public
Private
data? What you
Private
said, public data and private data, as you mentioned just now.
Your Lordship,
What is in public domain and what is not in public domain?
Your Lordship, both are not.
Now, is that which is not in public domain, is it an absolute right to keep it private?
Your Lordship, if it fulfills the test of Puttaswamy, it is. But otherwise, it is not. And here, that's what my submission was. It is not fulfilling the test of Puttaswamy.
All right, let us test your proposition by one example.
Your Lordship,
Suppose a person who has a communicable disease gets into a swimming pool and the supervisor at the swimming pool knows that. Is he entitled to go and complain to his boss that please ask this person to get out of the swimming pool because that person is suffering from a communicable disease? Yes or no?
Your Lordship, if the person who is communicating is public officer,
No, it's a private pool.
It's a private.
Let us assume it's a private pool
Certainly, Lordship.
where there is a person
Certainly.
who has got into the swimming pool who has a communicable disease.
Certainly, Your Lordship.
He has a right. Is
they
it
have the right to
duty bound?
complain, Your Lordship.
Huh?
Are you about complaining? They do have the right. And
Yes.
also, if it is the Lordship, life prevails, but it could be subject to certain restrictions.
COVID
established by
positive,
law.
not disclosing.
Not disclosed. Exactly. Something like that.
Certainly, Your Lordship. Lordship, proceeding with the fact, if the Lordships are kind enough to refer to again V.R. Shri Krishna report that has been mentioned under compendium, page number 19, paragraph 3, Lordship.
Yes, go ahead for the second issue. If you have
Lordship-
exhausted issue number 1, go
Your
ahead for it. You have only 1.5 minutes.
Your
Go ahead
Lordship,
for second issue.
I'll just take 2 more minutes. If it could extend for 2 more minutes, I will be able to summarize both issues.
All
Your
right.
Lordship, pertaining to proportionality, they
Yes,
should have sufficient
2
data
minutes
mechanism.
extended further.
Your Lordship, for sufficient data, they should have sufficient data mechanism at hand. Your Lordship, under section 8, subsection 5, they have just mentioned that sufficient safety mechanism should be there, but they have not laid down the provision that what entails under safety security mechanism. And when they overruled SPDI rules 2011, it is clearly stated under section 8 what falls within safety security mechanism, which means that you have to follow to international standards as well. And then clearly laying down the provision that you need to just follow an arbitrary, lay down a power that you just need to follow any provision which falls within security is violative of privacy. Secondly, Lordship, the other contention is that under section they have mentioned that they do follow with other compliances. Now, GDPR also mentioned that they have to be accountable enough. So they have taken some remedies from GDPR and they are not claiming other remedies, which means they also have to be accountable enough. They have intimidated in the present case, medicine company, intimidated the people about the breach only after fiasco was there, only that they felt that their reputation would be tarnished. Your Lordship, also under this said act, auditing of the company could be only done when they are falling within significant data fiduciary.
Focus on the issue, the leakage, it has happened.
Certainly, Lordship.
Whether at the time of accepting my subscription and further utilization is for the legitimate purpose or not. Come to that point now straight away.
It doesn't fall within proportionality, therefore it is violative of privacy. Dealing with the second submission, Your Lordship, due to paucity of time, I'll just not refer to compendium as such. The second submission lies on the premise that the processing of bank account details does not fall within the legitimate purpose. Your Lordship,
Yes.
flag 16 of compendium clearly states that.
Now you say that it is not legitimate. Just point out what is it
Certainly,
that
Your
made
Lordship.
them not to
Your Lordship,
legitimate.
there is a commercial intent behind taking and collection of our bank account details, Your Lordship. When they're stating that for medicine company, you don't need to give me you don't need to take membership and you can directly claim my subsidy. But they are putting a commercial intent behind when they're stating that you please take my membership. You pay some price, and which means you have to pay some price, then only we'll deduct some subsidy amount from health insurance
So
policy.
if
It shows the
your
commercial intent.
client knows that bank details are not required for the purpose of getting subsidy, then why did he submit?
Your Lordship, we did not know that they would store my information. There was a clear-cut bifurcation that it was not informed in
So
nature.
if somebody is asking you information which is not required, and why are you giving it?
Your Lordship, the onus
And
never
it-
lies on the petitioner.
And it is not mandatory for them, right?
Your Lordship,
To become a member.
Your Lordship, it is, Your Lordship.
Could have used the app alternatively.
Yes.
Your Lordship, Your Lordship, page 24 compendium clearly states the state interacts with the citizen. There's an imbalance of power between state and citizen.
No,
And
wait.
Your Lordship, I got
See,
the point.
we are saying there are two ways of becoming member.
Certainly, Your Lordship.
So you could have used the app if you don't want to give it.
Your Lordship, when
So
you provide-
therefore, when you are giving,
Certainly,
means you are voluntarily allowing.
Certainly, Lordship.
We'll extend one more minute.
Certainly, Lordship.
Yes, sir. Yes, sir. Go ahead, go ahead.
Your Lordship,
So it is a conscious choice of your client to give the information to them.
I understand the query raised by
Voluntary disclosure otherwise.
I understand the query, but I beg to differ, Your Lordship. When you're saying that you can take my membership through methods, wherein there was no storage of bank account details necessary. So for me, both options seems equally at equal footing. But when I later got to realize that this option where it even stores data, and me being a data principal and me being in a dire need of services required.
See,
Your Lordship,
when you are given it two options,
Certainly, Lordship.
and you knew that what is required for each option,
Your Lordship,
and you are not using A, but you are using B, means I knew what I am doing. There is no compulsion.
I beg to differ, Your Lordship. In the appendix, they have nowhere stated that they would collect my bank account details. How could I know? There was no informed consent as
The
per
moment
section 6,
you
Your
go
Lordship.
into the website and start filling the form, you see that there is a bank details, right?
Your Lordship, if the Lordship is kind enough, if BR Shekar report clearly states that when you're taking my consent, it means if I'm taking for example, if I'm stating I need X to perform Y, it should mean that I need X to perform Y. It cannot blanketly state that X, it falls within deemed consent. It had to be explicit in nature, and they have nowhere defined, Your Lordship. They cannot claim this exemption that for sensitive information, you can just put the blame on the petitioners or data principal, who are a victim right now, Your Lordship. We have our data, our life savings have been lost. It is not a small amount, Your Lordship. For state, it could be.
That we will go into the next issue when they are arguing.
Certainly,
Now we are
Lordship.
looking at is only whether the consent is there or not.
There was no consent, Lordship. And the last point, that what is beneficiary, Lordship? Beneficiary means
I think
one
you need
who
to
receives,
complete.
just 30 seconds, Your Lordship. Beneficiary is the one who receives financial assistance or subsidy without any consideration. What I have already pointed out, what was the consideration here? Therefore, they cannot say that data principals were acting as in consideration. And as per moot proposition, page 4, last 2 lines clearly stated that they were only providing benefit or subsidy, and state has all the right to carry forward an occupation, Your Lordship, under 19(1)(g). But herein, Lordship, just 10 seconds, and they were acting for their
think
commercial intent,
You
and
need to
therefore it is.
conclude.
Certainly, Lordship, I'll conclude. They have not taken consent because it nowhere specified. There is
Yes,
one
madam,
that
time up.
It's my honor to appear with this honorable court, and I would like to call my co-counsel to deal with the further submission.
Yes, please.
Yes.
Your Lordship, the Council will be dealing with two submissions, that is issue 3 and 4. The provision that provides immunity to central government under section 35 violates the petitioner's right to seek remedy, and exemption of certain data fiduciaries under section 17 subsection 5 by means of notification is an arbitrary exercise of discretion and is therefore violative of Article 14 of the Constitution. For the third issue, Your Lordship, if Your Lordship will please refer to section 35.
Go ahead, we know it, go ahead.
Section 35, the important words that are to be highlighted here is that no suit, prosecution or legal proceedings shall lie against the central government or officer or employee thereof. Therefore, Your Lordship, in the instant case, there is a blanket exemption that has been provided to the central government or its officers thereof as the case
No,
may.
if your right is violated under this law, where do you complain?
The council begs your pardon, if you may please.
No, you are saying that there is no remedy for you if there is a violation of this
No,
law.
no.
Is that what you are saying?
No. She says central government officials have got immunity and not the petitioner, this company.
Your Lordship, here.
No, is that what your answer? Because we have some doubt about what you are trying to say.
Your lordships, the medicine company falls within the definition of officer or employee thereof, because in the moot proposition, it has been established that all the employees of the medicine company are public employees.
Okay,
And also the medicine company is being controlled by.
That's what, madam, you say
Yes.
that you are immune,
Your lordship, we are the petitioners. We are saying that.
correct? Do you say that are you immune or not?
they are immune.
They are immune, your lordship.
That's
There-
what?
There is a complete blanket exemption that has been given to them.
Okay,
This blanket exemption violates right to seek remedy, which is a fundamental right.
1 minute. Now read issue number 3, please.
that's what I was.
Does the provision that provides immunity to the central government under section 35 on account of good faith violate the petitioner's right to seek remedy? Now it is not absolute. It is good faith. So if the immunity is conditioned by the existence of good faith, why is it bad?
Uh,
It is not a blanket exemption.
the council understands the query that is flowing from your lordship. However, the council begs to differ on the point that in this instant case, firstly, there have been medicine company and central government that are provided
No,
exemption.
1 minute, 1 minute. We will go to the facts of the case separately. First, let us look at the provision of law. Now, are you saying that the immunity granted under section 35 is absolute, therefore it is bad? Or are you saying in the facts and circumstances of the case, immunity is not available? What is your case?
Your lordship, the council is arguing that in the present case, the immunity acts as a blanket immunity to the central government and its officers. And therefore, as per the act also, in the mandate of, as per the mandate of the act also, this acts as a
See,
complete.
understand one thing, most of the laws have a similar provision. Even your Right to Information Act says, if a PIO acted in good faith, immunity is there.
Certain, your lordship.
So
the council-
therefore, the sir's question is, are you saying that that provision itself is unconstitutional, or in this case, this provision doesn't apply?
Exactly.
Your lordship, the council contains.
You are for the petitioner,
Certain.
go ahead.
Yes.
That clue also we have given.
Your lordship, the council contends that good faith has to be seen from the fact from the objective of the act. Now, in the instant case, and good faith can only be there when there is no, when there are no circumstances wherein central government or for
So,
that matter.
so what will happen now? So what will happen now for issue number 3?
Your lordship, the petitioners herein are arguing that this acts as a blanket immunity to them.
No, because your issue clearly says there is no remedy you can seek, but you are seeking a remedy saying that whether he acted in good faith or not, that can be questioned in the court.
Certainly, your lordship.
Therefore, there is a remedy in that case.
But your lordship, this.
For that reason, why should we strike down this statute?
Your lordship,
Exactly.
for section 35, good faith has to be proved. And second, your lordship.
No, that's there. That's there.
That's
Good
exactly
faith has
what
to
we
be
are
good.
saying.
Your lordship.
See,
The-
that's
Now, can
exactly
you
what we
say-
are saying.
Can you say provision will take away your right to remedy?
But your lordship,
Section 35, in your case, will it take away your right to remedy? Your petition whether could be entertained as against the officers of that company.
your lordship, in the present case, the council is arguing that every time there is a breach or something like this happens, because of section 35, they will have to approach the writ court and will have to prove that there is a violation of
Not
fundamental rights.
necessarily, not necessarily. Why you should go to the writ petition? Suppose whether the government or the member acted in good faith or not, it could be challenged under the normal court. What is the remedy given in case of violation of this act? Where the case goes?
Your lordship,
First you go through the chit. Now your friend has assisted you, go through the chit, madam.
the council
Yes,
gone through
then
it.
go ahead and answer.
Your
Don't get
lordship-
nervous. We are here only to test your capacity. You are on the right track. Don't get nervous. Please answer. The only thing that we are asking is whether your remedy is lost because of section 35.
Your lordship.
That's all the simple.
Your
We have made it simple.
And see, you have also relied in your submissions on section 3, subsection 22 of the General Clause Act,
Where the good faith is.
where good faith is defined. Now, suppose in a given case, good faith is not there and therefore immunity is not available. What is your remedy?
If immunity is not available, then proceedings can go on as per the normal procedure.
Correct. You can file a suit for damages, all that you can do. Why should we therefore strike down section 35?
Because your lordship, in this instant case, there have been various instances where there could be proof that because of this section, central government and the medicine company in the garb of good faith clause has actually violated the petitioner's right.
Therefore, they have acted in bad faith, according to you.
Certainly, your lordship.
Very good. If they have acted in bad faith,
Why 32
strike down the
petition?
like?
Why
strike
32
down the
petition?
statute?
Because your lordship, there a section can statute can uphold section the good faith clause only when there can be no circumstances wherein the central government or for that any officer can violate my fundamental right. However, in the present case, there have been instances on
How many people have been cheated, madam? We'll come to that. How many people has been cheated by this data
as
breach?
of now, approximately 4,500 people.
So 4,500 suits are the 32 petition.
But your lordships, but if we take that 4,500 petitions, but it cannot be a suitable argument when my fundamental rights have been violated, and secondly, when my life savings have been lost. In the instant case, even if we have to take the argument that medicine, if there is a breach on part of medicine company, the petitioners can very well go to the
No,
data
we just
protection.
want one last time I'm asking. Why should we strike down 35? Which is the constitutional provision which according to you is violated by section 35?
Your lordship, section 35 violates the principle of rule of law, and in the case of Nalini Sundar versus State of Chhattisgarh, Supreme Court has significantly reinforced the principles of accountability and rule of law in the country. Rule of law means no person or state can be above the law. In this instant case, the good faith immunity that has been granted to central government or for that matter medicine company has placed them above the objective of the law. This is very well established from the PR statement that has been given by Mr. Aditya. He has blatantly said that we are protected under the good faith immunity
Okay,
clause.
so I'll agree. Is there a data protection board?
Certainly, your lordship,
What is the purpose of the board?
your lordship, that any data principal who has any grievances against the consent manager.
So
can-
therefore, my question is, in this case, all your clients could have made
Approach
the board.
board.
Do they have that right to approach the board?
Your lordship, the council agrees on the fact that we
So
have-
therefore, even if it is 35 says you cannot, but you can approach to the data board and the board will say whether it is good faith or not.
your
Just
lordship,
to invite your attention, please see section 27.
your lordship, shall the council read section 27?
Section 27 of the Act.
Yes, your lordship. Shall council read section?
No, read, just look at it. Look at A, that's enough.
Yeah.
Look at A, that's enough.
The council understands the query. However, your lordship, if your lordship may please see the schedule. The schedule that is on the last page of the act.
Yes.
Go ahead.
Your lordship, the heading, breach of provisions of this act or rules made thereunder, and second, the third column is penalty. Your lordship, even if we as petitioners approach the data protection board and we say that our data has been breached, the only remedy that the data protection board could provide is that of penalty and not of compensation.
Okay.
The
We
we can be
understand.
provided compensation only when there is a suit that has been filed in the appropriate court.
Correct.
And when we'll file the suit in the appropriate court, it will be dismissed on the basis of the respondents or the state or the medicine company, as the case may be, seeking the bar of good faith immunity
No.
clause.
So therefore, when you file a case for damages in the court, when the respondent argue that there is a good faith clause, would the court will look into whether there is a good faith or not?
Certainly, your lordship,
So therefore, your remedy is there.
but your lordship, it results in delay of justice.
No.
If the court has to see,
How it is a delay of
because
justice?
your lordship, the court will have to go into making a preliminary issue. That is whether there exists a good faith on part of state
Exactly.
or respondent.
Council, you also have to keep in mind one thing in the context of what his lordship asked you.
Much of-
There is a presumption of constitutionality.
Certainly, your
So
lordship.
therefore, there is a heavy burden cast upon a petitioner who challenges the constitutionality to satisfy the court that a statute is invalid.
Certainly, your lordship, the
Do
council.
you think you have crossed that threshold.
Your lordship, the council certainly will satisfy the court that the court will be satisfied that the presumption will no longer be a presumption of constitutionality. Also, talking about presumption of constitutionality, it only is there if the surrounding facts and circumstances are not able to support that there is a violation of fundamental right.
In
How-
any event, would you agree that if your co-counsel succeeds on issues 1 and 2, the issue you are raising will be irrelevant?
Redundant.
Certainly, your lordship, because if my co-counsel has succeeded that there is a violation of fundamental right of Article 21 by the respondents, then the section 35 immunity.
Will automatically
All right.
fall.
All right.
Certainly, your lordship.
Issue number 4.
Coming to issue number 4, your lordship. Your lordship, if your lordship may please refer to section 17, subsection 5.
Yes.
The central government may, before expiry of 5 years from the date of commencement of this act, by notification, declare that any provision of this act, specific mention on the word any provision of this act, shall not apply to such data fiduciary or classes of data fiduciaries for such period as may be specified. Now, your lordship, in the case of State of West Bengal versus Anwar Ali Sarkar, twin test was laid down, wherein it was stated that when an act can infringe by when there can be first an classification must be an intelligible differentia, and secondly the differentia must have a rational nexus with the object sought to be achieved. And the same
Now
is
we
given,
don't use any more that, right?
pardon your lordship.
Article 14, we don't use that kind of interpretation anymore. What is the new concept of equality?
Your lordship, even after this too, the third concept, that is the in the instant case, the action is manifestly arbitrary, has also been argued by the petitioners. If your lordship may please refer, if your lordships want, the council may directly jump to first issue, sub issue 3, that is, it is manifestly arbitrary.
Yeah. That's what you are questioning, no? Article 14.
Uh,
Violation of
Indeed, your lordship, but there were 3 grounds. But if your lords would want,
We don't want to go into nexus because if you establish arbitrariness, we need not.
certainly, your lordship, the council would be arguing that the action is manifestly arbitrary. If your lords may please refer to.
That's what we asked your co-colleague to point out from the appendix.
So anyway,
You
she's
can
coming.
now.
How it is.
You can now
arbitrary is-
supplement.
Your lordship, the council is contending that the exemption, appendix 1, the exemption to classes of companies and agencies is arbitrary. If your lordship may please.
No, there I have a question for you. If a notification is issued under section 17(5), declaring that provisions of the act or some provisions of the act shall not apply to a data fiduciary as defined under the act, why can't you challenge that notification? Why challenge this section?
Your lordship, in the instant case, the prayer and the issue both states that the notification must be held arbitrary and violative of Article 14.
No, one minute. If you say the notification is to be held to be arbitrary, maybe you're right. In a given case,
Much obliged,
strike
Your
down the notification. Why strike down the source of the power to issue notification, namely 17(5)?
Your lordship, in the instant case, section 17(1) to section 17 subsection 4, they grant certain factors and grant certain classes of data fiduciaries which may be exempted from certain sections of the act in certain conditions. However, in the present case, central government, in pursuant to section 17 subsection 5, has arbitrarily exempted the companies and agencies from all the provisions.
What sir is asking is whether 17 clause 5 is arbitrary or the government notification is arbitrary.
Your lordship, in the instant case, the prayer that the petitioner is asking with respect to issue number 4 is that the notification must.
So
be-
you are not questioning 17(5).
Certainly not, your lordship.
Okay.
So your lordship, the council will be satisfying how this notification is arbitrary and violative of violative of Article 14. If your lordship may please refer to memorial page number 14.
Yes.
The court in
So to understand that the notification issued by the government regarding Indian Railways, insurance, etc. is fine, but it is not fine with only with the medicine company. Is that what you are saying?
your lordship, the council is contending that all the exemptions, all the companies that are included. However, since the facts are not paramaterial to that of India, the council cannot satisfy the court as to how all
What
the
is the test of arbitrariness in regard to serial number 6 medicine.co? Simple point.
Certain your
Come
lordship,
to
the
that,
council
and then,
will-
say.
the council will satisfy the
We are
court
not
as
worried
to-
about IRCTC and other things. Notification is a whole notification of which you are interested in serial number 6. That's all.
Your lordship.
And when you're answering that question, just answer this question also. Please look at the nature of this medicine company. See, it is a company of a special kind because it is the country's largest online pharmaceutical company. It offers subsidized medical services, supplies, and insurance through the insurance company. And therefore, it provides as a public sector undertaking,
Catering to the,
catering to a very
large section of
important
the-
need of the people. So
Certain-
why can't that company be treated as a class by itself?
Your lordship, the council very well understands the query and the council appreciates the fact that your lordships has acknowledged the fact that medicine company is treating data of a larger section of the society. Now, if your lordship may please come to the.
all right, I
objective of
collect the
act.
data, then will it become the notification arbitrary? I collect the data.
Your lordship, the council.
What
will
is
be
the stage at which that the arbitrariness
Certain
will
your
be
lordship, the
tested?
council will be satisfying the court that how is it arbitrary? Firstly, the court, the council is kind enough to, the council appreciates the fact that your lordships has acknowledged that they collect larger data of larger sections of the
No,
society.
that is there in the statement.
Now, your lordship,
We further acknowledging
your
will not come.
lordships, the objective of the act is to provide for processing of personal data in a manner that recognizes both the right of individuals to protect their personal data. So your lordship, if an entity in the present instant case medicine company is collecting data of so much of a larger section of the society.
Just a minute, just a minute. If the data is not breached,
So
then the notification is arbitrary.
your lordship.
No,
e-
please.
Even then the.
If the data is not breached, let us say,
Certain-
data continues. Company goes on, no list. Now, can you say that the notification is arbitrary?
But your lordship, in the instant case.
Is it not a contingent in a thing that has happened? Can it be retrospectively treated as arbitrary?
Exactly.
But your lordship, in the present case, the medicine company has actually taken the defense that they have been exempted under section 17 subsection 5. It is
I'm
im-
entitled to because notification says so.
Your lordship, it is important to understand that they collect personal, that the objective is to protect the personal data of individuals. Now, your lordship, from the exemption and from the immunity clause, firstly, they are having the protection of good faith immunity clause. Secondly, they are having the protection under the notification that is released in pursuant to section 17 subsection 5. By these two protections, they are on a bigger pedestal even than the objective of the act. Because in this way, if I as a petitioner, my data is breached, I can nowhere go for the remedy because they can simply say that they have been exempted under section 17 subsection 5. And with this defense, the objective of the act, which is to protect my personal data, will never be fulfilled. Because your lordship, they are not under an obligation to comply with any.
No, 1 minute. You just now told us that you are not actually questioning 17.5. You are only questioning the inclusion of medicine company in the list of exempted entities.
Certain, your lordship.
Please look at your prayer. Prayer number 4. Are you modifying your prayer? To declare section 17.5 of the Act violative of Article 14, therefore unconstitutional. Therefore, you are questioning the whole of section
Your lordship,
17.5.
prayer reads the exemption of certain data.
No, we were very clear when we asked you the first question, are you attacking 17.5 or the individual notification?
Exactly. So what is, you give us an answer that you are attacking the individual notification.
Certain, your lordship, the council's, the prayer reads the exemption of certain data.
If you are questioning the individual notification, would you like to amend your prayer? We
Look
are
at your
repeating
prayer.
that. We are repeating that.
Look at your prayer, please. Declare section 17.5 of the Act violative of Article 14, therefore unconstitutional.
Your lordship, the exemption of certain data fiduciaries, the council
Assume
feels
for
that in the-
assume for a moment that if we allow your prayer, just look at it. Well, Medicine and Co has violated, therefore that particular notification, removing medicine and co is okay. But what are the others who have to do?
But your
They
lordship,
are
all-
doing they are doing their business as per the requirement. Tomorrow everybody comes up and files cases against these people also. If you take 17.5, who will come forward for business in this country?
Your lordship, the council understands the query. However, the council begs to differ on this point. Your lordship, all these are as already stated, these are public companies. They're performing.
You have the nose running. Will you cut the nose
But
or cure your running nose? Simple, no?
Your lordship, it is important to understand that in the present case, the objective is to protect the, is to
So
proceed
you will now attack 17.5 in the context of the present cases with regard to serial number 6 in the notification.
certain, your lordship, your lordship.
See, the problem is only this much, what my lord is telling you. If we grant the prayer holding that 17.5 is unconstitutional for whatever reason,
Certain.
and accept your
Much
contention,
obliged, your lordship.
then even Reserve Bank
That's what.
will not get the immunity, will not get the exemption, I'm sorry, will not even get the exemption, because if you see, IRCTC will not get it. The Life Insurance Corporation will not get it. The gas company, none of those companies which are purely,
And they are doing their business in a very normal, prudent way.
so you.
And they need the data because they want to make sure that, their services are reached to a genuine person.
Absolutely.
Your lordship, the council begs to differ on this point that the act's objective stands on a higher pedestal than the
Tell me the 17.5 object then. Please tell me the 17.5 object. The whole object of 17.5 inclusion in the statute book is to protect a genuine data for collection agency. That's all.
Your lordship, but if that could have been the objective.
Otherwise, everybody will go for 17.5, no? Nobody will come forward. If I don't have data, am I selling the grocery in the open market? No, these are all specialized services.
Like take for
Individual
example,
requirements is
take
necessary.
for example, Reserve Bank. I mean, would you say Reserve Bank is on the same pedestal as medicine company, and therefore if medicine company goes, Reserve Bank also must go from section 17.5 notification?
Your lordship, firstly, medicine company is the biggest online selling and buying of pharmaceuticals in the country of Indiana. Secondly, if we talk about Reserve Bank of India, as per the report of 2023-2024, they have approximately 300 crore bank account details. That means they have the data of so many citizens. If they pursue,
If I commit a breach, I am also liable. Just because I am RBI, I will not get away. If I commit the breach, it is not good faith. No 35, no 17.5.
But your lordship,
Individual case, you can have the power, not the otherwise.
the council seeks extension of 2 minutes.
Yes, go ahead.
But your lordship, even if we
Please,
are to,
now also, having had this discussion, would you reframe your arguments for the 17.5, or you would like to still stick on to say that 17.5 is unconstitutional?
your lordship, the council would like to state
2
that
minutes
the
is given for that.
exemption, that the exemption that is granted by means of a notification in the present case to all the companies and agencies that are listed is arbitrary and thus violative. All. Is
Yes.
Violative.
Thank you. Thank you.
So does it mean, I'm just helping you out. I know that there is a heated discussions. Does RBI being an RBI get any immunity from breach of data? Should we?
Your lordship, the council begs to differ on this point that RBI, only by being RBI, does not get any protection from.
That's what we
personal
said,
information
no?
data.
That is what we said, and still you want to say 17.5 unconstitutional.
No,
Does
she's
not-
saying RBI doesn't get any benefit.
Should
Should not
not
get
get.
Should not get.
Should
Should not
not
get. That's
get.
her-
And in
that's
the
her
present
stance.
That's all
instance
right. We
case,
understand your
Yes,
point.
I agree. That's
Yeah, we
what,
understand
that's
your
what we are looking for.
and that is what the council is contending, that from this exemption, the RBI would be at a higher pedestal that my person.
So therefore, what you're saying is that the law is meant to prevent or protect
My
data
personal-
protection.
Certain-
Therefore, there can't be data breach, whether it is by RBI, whether it's by
Certainly,
medicine
Your
company or by X, Y or Z.
Any company.
Yeah, I
So
understand.
therefore,
We understand.
you should have attacked 17+5. That's what.
That's what they're saying. She has done that. Yeah,
Yes,
go ahead,
please.
go ahead. We understand your point.
Yes, so time up.
One more.
No, one more. Anything you want to conclude?
Your lordships, and if the respondents state that the exemption is in the interest of prevention, investigation, etc. Because there are certain companies in the list that that may do these functions. Your Lordship, certain criteria or factors are already provided under section 17 to subsection 4, wherein there is a very specific list that under certain conditions, certain data fiduciaries do not need to comply with certain provisions of the Act. However, the notification that has been released, it gives them the exemption from all the provisions of the Act. That is why in the instant case, my personal liberty or the objective is at a lower petition than the exemption at a higher petition, which is again a notification.
No, it was not a blanket, madam. Please understand, it was not a blanket. All right, you have done your good. Take
Uh,
your seat.
The council seeks permission to proceed with the prayer.
No, we understand.
We understand it.
Much
Yes,
obliged,
thank you.
Lordship. It
Thank
was
you.
an honor to argue before this honorable bench.
Thank you, come and take it. Yes. Wait. How much time we have granted extra for this team? We just look at it. Total, how much time extra we have granted? For the whole team. 2 plus 2 plus 1 plus another 2. Huh? Right,
7 minutes.
7 minutes. Okay, the seconds, nanoseconds you are not counting, no? All right. 7.7. Yes, please.
Greetings to the respected bench. This is, am I audible, Lordships?
Yes.
Greetings to the respected bench. I'm Counsel 1 appearing on behalf of the respondents for the case.
Would you turn little this
Indeed.
side? You are putting the back to the people. You can take it. That
Indeed.
would be fine. Yes, that's it.
Your Lordship, this is Counsel 1 appearing on behalf of the respondent for the case concerning Amin and others versus the Union of India and another. Counsel 1 would be dealing with the first and the fourth issue, and for which counsel would be reserving 22 minutes for the submission, and counsel number 2 would be dealing with the third and the second issue respectively.
Yes, sir.
Lordship, before proceeding further, if your Lordships have any preliminary questions that the council would like to answer, the council is most obliged to.
No, as and when you argue, we'll put the
Much
questions.
obliged, Your Lordships, before proceeding further, Your Lordship, before proceeding further, I would like to make few preliminary objections to the points that was raised by the counsel for the petitioner, Your Lordships. Lordships, firstly, with regards to section 35 of the DPDP Act, Your Lordships, whereby it was admittedly stated by the counsel for the petitioner that there was
No,
a...
1 minute. Now we have all understood the facts.
Indeed, Your Lordship.
So let's go to the legal issue straight away.
Indeed, Your Lordship.
Now, how can you use data which you have collected, making one promise for another purpose, and then say, I had immunity under the statute, therefore I can do anything on the surface of this earth?
Indeed, Your Lordship. I like to answer the question in two ways, Your Lordships. Firstly, to answer the issue with regards to the privacy notice, Your Lordships, the counsel for the petitioner have left out one key clause of the privacy notice, which is of importance, Your Lordships. Taking Your Lordship's attention to the last annexure number 2 of the moot proposition, Lordship, it is pertinent to mention that the first page of the annexure talks about payment details, which is collected by the data fiduciary in instant case, Your Lordships. It includes, we collect data necessary to process your payment if you make purchases such as your payment instruction number and security code associated with your payment instruction, Your Lordships. Lordships, to understand what is processing, section 2 clause X of the DPDP Act needs to be seen. Processing is defined as something which includes both collecting as well as storage of data, Your Lordships. Lordship, taking Your Lordship's attention to the clause number 8 of the privacy agreement, Lordship, it specifically states, for other business purposes, we may use your information for any other business purposes, such as data analysis, identifying usage trends, determining the effectiveness of our promotional campaigns, and to improve our site's product, services, marketing, and your experience, Your Lordship.
And stealing away money from your
Indeed
account.
not, Your Lordship. That has never been the intention of...
No. If you had stated that, then I would have not given consent.
Your Lordship, that has never been the intention of the respondent.
You have done it.
No, it may not, let us be clear. We are not attributing any intent.
Indeed.
But the fact remains, you admit that on account of the data having been stolen, the beneficiaries who have become members of this company have lost money. Do you?
Indeed, Your Lordship.
India. So point number 1. Do you agree that this way in which people have lost money, 4,500 innocent people have lost crores of rupees, was not the object of collecting data?
Indeed, Your Lordship.
Then you appointed Razor Pay,
Safety GPT.
Major Pay.
Indeed, Your Lordship.
Now this data breach occurred on account of a snag in the AI of Major Pay.
Indeed.
Who is responsible for it?
Your Lordships, the council would like to answer this question by first referring to section 28 of the DPDP Act, Your Lordships. Section 28
We
talks
ourselves
about
have referred, you go ahead.
procedure that needs to be followed by the board, Your Lordships. Specifically, clause C of the said section talks about the board shall determine whether there are sufficient grounds to proceed with an inquiry. Your Lordship, this is the prima facie case which needs to be made out by the petitioner as to whether there is a goodwill or a good faith or it's a bad faith, Your Lordships. And therefore,
No, if that is so, why did you give that public statement?
Your Lordship,
You know that you have committed a blunder, therefore you wanted to pacify the people, therefore you came out with that statement.
indeed not, Your Lordships. The council would like to answer.
Please read,
Indeed.
please your public statement to pacify the
Indeed,
people.
Your
The
Lordships,
chaos that happened in your company, you would have lost your life. Therefore, you gave that statement as an insulation.
Your Lordships,
You never talk about the immunity there. You never talk about the privacy clause. People would have done to death.
Your Lordships, to answer this question.
No, please
Indeed.
see your statement,
Indeed,
what
Your
you have given. Whatever that you are trying to now argue is not part of your statement.
Indeed,
You
Your
cannot
Lordships.
approbate and reprobate.
Your Lordships, the statement was given by the official of the company and
you
lacks the legal,
disown- you
lacks
disown.
the legal
You disown
knowledge to
that.
interpret
You
the.
disown that.
Indeed not, Your Lordships.
And
Your
then leave
Lordships,
it at that, no?
Your Lordships, the council would
It
like
is
to answer
warranted
this.
on behalf of the company, sir, to save your skin
Your Lordships, the
from the
council,
wrath of the public who have lost their hard-earned money by
Uh,
your mischief.
Your Lordships, the council would like to answer this question by saying,
No, please tell me,
Indeed.
look at the statement that you have given. Whatever you are arguing is dead against what you have given the statement.
indeed, Your Lordships. Your
Read,
Lordships,
no?
referring to the.
Read, no?
Indeed.
There is a what is called principles of estoppel, no?
At Medicine Co, all data collected during the membership process is in full compliance with the provisions of the Act 22 of 2023. And the
Not
Act
in
does-
percents of what you are given in the website.
Indeed,
It
Your
is
Lordships.
only in respect of your act.
Indeed. We have
Then
not.
what for the purpose of the giving it in website? I did not know. It is directly taking me to the dead end.
Your Lordships,
I have lost everything.
Your Lordship, the council would first answer.
No, I have lost everything, no,
Lordship.
because of your website.
Thank you, Your Lordship. Your Lordships, the first question that needs to be answered at this particular juncture is the imputability of liability, Your Lordships. Now, the question is whether Medico has to be liable for the breach or whether Safety GPT, which is a third-party organization, ought to be liable for these breaches, Your Lordships. And formal procedure and investigation process has to take place by the board. And in the instant case, such an right to seek remedy has not been denied to the petitioner.
No, that's not the question, Mr.
Indeed.
Counsel. Now look at the object of the statute. Let us see the primary purpose of the statute. Primary purpose is to protect the right of individuals to their personal data. That is, right of individuals to protect their personal data. This is the objective of the statute. Any provision which dilutes this objective has to go. Now, how do you therefore say, well, there is a exemption granted to me, there is an immunity granted to me, and therefore I can do whatever I want. Now, let us assume for the sake of argument that this statute was not there. Would you not fall foul of Article 21 and the law laid down in Putswami?
Your Lordship, to answer this question, in case this particular legislation was not in place, the data would have been covered by the SDPI rules of 2011, Your Lordship, which specifically deals with sensitive data protection. Now, this particular legislation has specifically omitted, is a new regime that replaces the previous regime of
Let
SDPI.
me assume
Indeed.
that in this country, there are no data protection law at all.
Indeed.
Would it not get protected in Article 21? Having regard to the law laid down in Putswami.
Lordships, for this, the council would like to submit the compendium for your Lordship's benefit and take your Lordships through the Puttaswamy judgment to establish that the right to privacy has not been violated in the instant case with reference to the doctrine of proportionality, your Lordships.
One more question here itself. Your so-called AI itself says safety GPT. Where is the safety? Point number one. Point number two. Because you said it is safety GPT, I took it. It is like vaccination. Even after having the vaccination, if I contract COVID, what is the purpose of taking vaccination?
Your Lordships,
Thirdly, you had an agreement with what was that major pay, where that tripartite agreement that is between you, the data that has been given by the customer or the subscriber and measure pay. Ensured at any given point of time that only for these purposes it's in the website, it will be used, and any violation thereof, I owe the responsibility.
Lordships, to
Yes.
answer this
Now,
question.
just last observation.
Indeed.
Please realize that the facts are loaded against you.
Indeed, Your Lordships.
Yes.
You are taking protection under a statute depriving 4,500 people of their money.
Your Lordships, the
Hard
council
on.
would like to answer that question by saying that it was in this particular instance alone, based on merits of the case, there has been an alleged violation of breach to this 4,500 customers, Your Lordships. Secondly, the
If
first,
it is only an
as stated
allegation,
earlier.
repay them, no case is closed.
Lordships, as stated earlier, the first step that needs to be taken is the imputability of damage. And since it's a case under Article 32 of the Constitution, where the constitutional validity of the provision is challenged, the council would like to stick to the law at hand to establish that the provision itself is constitutional in nature.
Mr.
If your
Council,
lordships-
please accept the factual aspect that the people have lost money.
Indeed,
With
Lordships.
that, you should start and then say, what for the Constitution then?
Your Lordships, the people have lost their money, Your
And you
Lordships.
are-
Since
and
the
you are
investigation,
taking shelter under the safe harbor provision contained in 17(5).
Your Lordships, the people have lost their money, but since the final investigation is not complete in the instant case, I cannot attest to the fact that how this particular data or how this breach has happened, Your
So
Lordships. And therefore,
you are saying that this is only constitutionality. When it comes to the
Indeed.
damages, there is a separate investigation.
indeed, Your Lordships, I completely agree with Your
So
Lordships.
you're not against that.
Indeed, Your Lordships.
Okay.
Your Lordships, it is the humble case of
Is
the
it a-
respondent that the section 35 does not take away. the
An ancillary there. 4,500 people coming to the civil court, exhausting their remedy. We have seen Bhopal gas tragedy. We have seen the judgment of the Supreme Court there. Whether the civil suit for damages could be a equal and efficacious remedy. If it is so, what for 32 meant for, and why are we sitting here? Should we always say you have an alternate remedy? Go there, die. You will not get back your money for generations to come. Or should we raise to the situation, protect the data of the people, not to happen this type of things in future? Should we not entertain the petition and pass appropriate orders?
Much obliged, Your Lordships. To answer this particular question, the first course that the petitioner ought to have taken was to approach the board to check whether this particular instance where the Medico has acted, whether was it in good faith or bad faith. Only when if the board decides that it was indeed in bad faith or it was indeed in good faith, the proceedings will not happen according to section 35 of
That's
the.
only for penalty, sir.
So
Indeed not, Your Lordship.
So
It is
35
only for the penalty.
So 35 is also applied to major pay?
Your Lordship, it is the humble submission of the respondent that being major pay being an instrumentality of the state in the instant case, same would apply to major pay also.
Now, let me assume for the sake of argument that the data breach was because of a bona fide reason. Okay, that may absolve you of liability to pay damages. But whether it is bona fide or whether it is mala fide, my right is affected.
Indeed not, Your Lordships. To answer that
Why?
specific
I lost my
question,
money.
Your Lordships, 28 clause 3 of the DPDP Act specifically gives the power to the board to do a preliminary inquiry as to whether there is, with regards to any case, Your Lordship. That includes whether it was done on good faith or bad faith. And therefore, the audioltrum partem or the right of natural justice has not been denied to the petitioner in any case, Your Lordship. That is the humble submission of the respondent.
So what you want to say is powers of 32 is subsidiary to the board powers, is it?
In case the board decides.
You please make this point clear.
Your Lordship.
Board is superior to the 32.
Indeed not.
And therefore, we should tie our hands. Board is there. You will pay 10 rupees penalty, go there and walk away.
Your
At
Lordship,
the end of 5 years that, it was not in the good faith. What do I get? Sir, look at me. My petitioner, look at me.
indeed.
Aged people, they wanted some discount for their ailments. They invested money. Otherwise, they would have bought it in the regular shop itself. Why online? They can't move out. Their children are not there. It is delivered to the cost. I was lured by all these small things. It is like, a prey in the fishing hook.
Your Lordships, it is humbly submitted before
I
this
got
honorable
caught
court.
in a net.
Indeed, Your Lordship. Your Lordships, it is
No, no.
humbly submitted before this
And then-
honorable court that this particular case was
No,
admitted before
please
the
tell
Supreme
me,
Court.
you want to say board is the one which has to inquire, therefore no 32 is maintainable. Is it your stand?
Lordship, the
If you
stand
say,
of the
if you say, yes, we will consider and pass orders.
Lordship, the stand of the respondent is that there is an alternative remedy available at the hands of the petitioner.
Is
And
it
there is no-
efficacious?
Your Lordships,
Is it efficacious? Please point out from the board, what is that remedy that they can give? They can only penalize you. No other remedy can be granted by the board.
Your Lordships,
Assuming that the board gives an opinion, am I not debarred from challenge in the civil court that this is, board is this only for the penalty, therefore damages I
Indeed
can
not.
still continue?
Lordships, in case the board decides that there is indeed a bad faith in the operation of the respondents or the company in the instant case, it does not.
You will only get absolved for the paying penalty,
Indeed
sir.
not, Your
Please
Lordship.
understand,
Your
civil
Lordship.
remedy doesn't die. Board will decide. If you have acted in a good faith, yes, you are not liable for the penalty. What about my money?
Your Lordships, that's where again stating the imputability of damage, where safety GPT is the one that needs to be imputed damage.
It is
Your
your
Lordship.
safety, sir, not my safety.
Indeed, Your Lordships, Your Lordships are, Your Lordship, it is pertinent to mention that the issues have been framed by the Honorable Supreme Court and it's up for final hearing. And the issues are very specific as to the very
Issue is specific, therefore I am
Your Lordship,
asking
the
you,
issue is not
nowhere in the issue, the question of board or 28 is there. Please
Indeed, Your
understand, neither in your testimonials, nor in the facts, nor in any of these things, the question of board should be, first you must exhaust remedy before the board, then come to 32. That is not the idea.
Your Lordship, that's not exactly what the council
Then
is trying to
don't
establish,
argue
Your
that
Lordships.
point.
Your Lordships,
You cannot
Indeed, Your Lordship.
argue that a board is superior to the Supreme Court.
the council is not arguing that, Your Lordship. The council is merely stating that there are alternative remedies available. That's it,
No,
Your
no, no,
Lordship.
no.
With
One
the-
minute, 1 minute. Your argument goes against section 39. Please look at section 39. No civil court. Please read it.
No civil court shall have the jurisdiction to entertain any suits or proceedings in respect of any matters for which the board is empowered under the provisions of this act. No injunction shall be
Oh, stop
granted
there.
by.
Oh, injunction, forget
Indeed,
it.
Your Lordship.
Now, how do you get over this? Now, even if the board holds one way or the other, it is, your argument is that is it intra-virus, the power of the board. Now, if it is intra-virus, the power of the board, then how do I maintain a suit having regard to the first sentence in 39?
Your Lordship, the council would like to kindly excuse the council in this instance case because council number 2 is dealing with the second and third issue. The council would just like to say that I haven't started anything with my first and final issue.
Right.
If Your Lordship please permit, the council would like to do the same, Your
Go
Lordship.
ahead, go
Much
ahead.
obliged. Your Lordship, the
Go
council,
ahead, go ahead.
the council takes Your Lordship's attention to page number 10 of the compendium, which has been submitted by.
But he should be ready. He cannot say my friend has not argued, therefore.
Indeed, Your Lordship. Your Lordships, if my co-counsel is not answering the question, I will do it in
I'll come
rebuttal,
back.
Your Lordship.
You're saying I'll come
Definitely,
back.
Your Lordship.
All right, go ahead.
Your Lordship, taking Your Lordship's attention to page number 10 of the compendium, specifically in paragraph number 313, Your Lordship, in the judgment of K.S. Puttaswamy versus Union of India, the Honorable Supreme Court has given a three-pronged test to determine whether there is a violation of privacy or not, Your Lordships. The three-pronged test being, the first requirement is that there must be a law in existence. In the instant case, it is pertinent to mention that section 7 and section 17 is a exception or the procedure established by law under Article 21, which therefore restricts the right of privacy in the instant case, Your Lordships. Second, the second requirement is the requirement of need. To understand the requirement of need, the preamble of this particular act needs to be seen, Your Lordship. It is pertinent to mention that the preamble gives two twin objectives, Your Lordship. The twin objectives being one, to protect the personal data of the individual. The next is to process data in a lawful manner. And therefore, since section 4 recognizes the usage of data for legitimate use, it's considered as a lawful manner, Your Lordship. And therefore, the second requirement is also established. And the third requirement is with regards to proportionality, which was also later discussed by the Honorable Supreme Court in the case of Anuradha Bashim versus Union of India, whereby taking reference to the arguments placed by the Council 1 for the petitioner, Your Lordships, the Council would like to refer to section 7C.
So when you're referring to that, please see section 4 again.
Indeed, Your Lordships.
Brother has
How do you-
already gone through 7C, you will have to cut that.
Okay, indeed.
You go to section 4.
Indeed, Lordships.
A person may process the personal data of a data principal only in accordance with the provisions of this act and for a lawful purpose. B, for certain legitimate use. Now, who is going to determine whether it is legitimate or not? It is not giving unguided, uncharted power,
Arbitrary. in
arbitrary.
photo.
Therefore, we'll strike it down.
Your Lordship, it is pertinent to mention that this particular section has been has similarities to the European Union's GDPR's legitimate interest provisions, Your Lordships.
Then what
Your
is
Lordships-
legitimate?
Indeed, Your Lordships, the
What is legitimate?
Your Lordship, there's been tests that has been laid down by the European Union's court, whereby three-pronged test has been determined with regards to
Exactly.
necessity,
Come
purpose.
to A, B, C.
Indeed,
Yes.
Your Lordship, the same necessity, the same prong test was also discussed by the Honorable Supreme Court, which the council just mentioned.
Even in the Putswami, their lordships have acknowledged.
Indeed, Your Lordships.
Yes.
Lordship, it
See,
is
look
pertinent.
at what this Honorable Supreme Court said in Shreya Singhal. When it came to Information Technology Act, they struck down those provisions which they said was very vague, even though it was argued that it comes within the purview of Article 19(2).
Indeed, Your Lordships.
And then said all these are very vague. Now, what is his legitimate purpose? What is legitimate to you may not be legitimate to somebody else.
Your Lordships, the legitimate use
The
clause.
very word legitimate itself is a subjective term. It has to be more objective, especially when fraud is alleged.
Your Lordships, to answer this specific question, Your Lordships, the term legitimate use has been defined in the DPDP Act. What is it? To be, indeed, Your Lordships,
Yes, yes.
just a
they are
minute.
defined, they are defined.
Under subsection D, Your Lordships.
It will
Certain-
always be read with 7 also.
7, Your Lordships,
It is
indeed.
complementary to each other.
Your Lordship,
7B to I,
section-
7B to I are the ones which would be falling under the what is
Your
legitimate.
Lordship, section 7A to I talks about the specific instances which can be turned by as a legitimate use, which was given by the legislation using
So
its
if
all
it-
parliamentary
Yes,
wisdom, Your
yes,
Lordships.
yes, you are right. Therefore, now A to I, when we test this facts of this case, it will not fall in any of A to I. Therefore, now tell me, if it is not falling under A to I, how it is
Your
legitimate?
Lordship, in the instant case, it does fall
Where, please.
under
please
section
point.
7B.
We had put that
Seven-
question to her
Seven
also.
B, Your Lordship, 7B. Your Lordship, reading verbatim, for the state and any of its instrumentalities to provide or issue to the data principal such subsidy, service, certificate, license or permit as may be prescribed, where she has previously consented to the processing of her personal data by the state or any of its instrumentality, Your Lordship. In the instant case, Medico is an entity, online pharmaceutical industry, which provides medicine at a subsidized rate to the,
Now, you are saying, okay, I agree that, but it says she has previously consented.
indeed.
Now let us look into whether there is a consent given by the petitioners.
Indeed. Your Lordship, taking Your Lordship's attention again to the privacy notice, Your Lordship, if Your Lordship may please,
Let's see. first
much
we
obliged. Lordship, the very last clause 8, which talks about business purpose, where it specifically the consent has been taken from the data principal with regards to usage of this data for other business purposes, which enhances user experience, Your Lordship. As the last word suggests, for any business purpose, the data can be used, which improves your experience. The very sole reason why Safety GPT was employed in the instant case was to improve the experience of the.
Agreed, but it did not fulfill that promise. Okay, it went out of hand. So therefore, now how do you take the benefit of B?
Lordships,
How are you going to take the benefit of B saying that it is a consent?
Your Lordships, the collection of data or the processing of data is what section 7B states, Your Lordships. Lordship,
See,
the.
I understand if you have taken my data, analyzed what is my purchasing trends and send me some kind of advertisement, medicines, etc., that's fine. But here, my data is gone to somebody who wiped up entire my money.
Hard-earned money.
So therefore, how could you justify that part of consent given?
Your Lordships, the consents were indeed taken from the data principal with regards to the bank account details, Your Lordships.
Correct.
Pursuant to section clause 8 of the document, it was transferred to a third party.
My
Lordship,
bank details can be used by you for what purpose?
for business purpose in order
No,
to improve
only,
your
only
experience.
for payment purpose.
No, agreed, even for business purpose, agreed. But business purpose doesn't look like you get all my passwords, everything and wipe off my money.
Indeed, Your Lordship.
Therefore, I don't think you could
It's
justify.
a
Your Lordship,
legitimate.
Your Lordship, arguing on equity.
What was
argue-
supposed to be the legitimate had turned out to be illegitimate by making use of the so-called the provisions of law
Your
and jugglery of the words.
Now,
Your Lordship,
now to
So many
extend,
if Your Lordship
yes,
may
2
please
minutes,
explain.
now to
Yeah, much
extend
obliged.
the point that my lord mentioned. Therefore, by doing what you have done, assuming it is bona fide, I am not for a moment suggesting that what you do is bona fide, the object of the statute is defeated.
Defeated.
Your Lordship,
Therefore,
to answer-
our question, then my lords has bombarded you with so many questions before starting your argument, is that, is there some concern from your client, that is the state, that yes, we collected the information, bona fidely we collected the information, something went wrong, people were drastically affected. What actions that you are going to take
Your
rather
Lordships,
than arguing that we are not liable?
indeed, Your Lordships. Your Lordships,
Did
indeed taken.
did you call upon the safety GPT or the other one? Where exactly we have gone wrong? Did you make any attempt to retrace your steps?
Your Lordships, attempts were indeed made by.
That is the only point, no? That is where we can judge your bona fides.
Indeed, Your Lordships.
If you are not a party to such a fraud.
Your Lordships, attempts were indeed made by Medico when, after knowing about the alleged breach of data, we had ordered for erasure of all the data that was in possession of Medico. Your
That
Lordships.
is for the future.
Secondly, Lordships, if in case if your Lordships were to decide that there was indeed based on equity there has been a violation of breach, Your Lordships, it is humbly contended before this honorable court that we are not present with the report of the final investigation, number one, and secondly, if at all any liability is to be there, the respondent would humbly be the petitioner to file a case against Safety GPT to bring them to justice.
Sir,
And
But just now you argued that Safe GPT also would come under the same immunity.
no, indeed not, Your Lordship. Medico is the one that will come under the immunity.
No.
Safety
no, we
GPT will
put
not
that
come.
question, you said it will.
I must have misunderstood
Because, no,
the
no,
question, Your
you said
Lordship.
it's a subsidiary. Yes, yes.
Major pay.
Major pay, he said.
Yes, Safety GPT is not it's a private entity and will not be covered under the exemption.
No,
Sir-
no, I'm going one step further. I'm assuming that the breach is bona fide. Still, I would say, why should I give my data to a person who is undependable? Like you.
Your Lordships, the very sole intent in which this Safety GPT was indeed hired by the government or the Medico in the instant case was because they were the leading safety data processor in the instant of data in the instant case. And since it was within the public knowledge, even the respondent in good faith entered into an agreement with Safety GPT. That's the
One
only.
more minute, just
Wind
conclude.
up, wind
Your
up.
Lordship, one more minute. The council will just move on to the last issue, 17 clause 5.
Just a second, just a second. Please tell me. Now you have said you have made your stand clear. Erasing the data subsequently after the entire incident has taken place, how it has improved either you or me?
Your Lordships, for this, the council would like to answer by
Because
defining what is a good faith.
No,
Your
please,
Lordship.
please, because you say
Indeed.
that the first issue is whether we can grant any relief to the people, petitioner, and similarly placed people
Your Lordships, first
without
issue,
going to the any other ordeals of requirement. Please tell me,
Your Lordships,
how is that going to help? You want to transpose as a petitioner. Well, we have allowed you. You are the petitioner. Tell me, what is it
Your
that we
Lordship,
can
the
do?
first issue the council would like to clarify is whether section 7 and 17 is constitutionally valid, Your Lordship,
So you
applying
don't
the
want to now
proportionality
become
principle.
petitioner.
Your Lordship, that is
Now
the
you don't
council.
want to become
Your
petitioner.
Lordship, the council agrees to being a petitioner for a separate proceedings before any court of your choice, Your Lordship. That the council is not
You
denying. The
cannot
council is
pick and
humbly.
choose, sir.
The
Yes,
council is humbly.
One more minute for
Much
the
obliged.
conclusion of the
Lordship, with
second
regards to the final issue as to whether section 17 clause 5 is violative of article 14, the council would like to answer both section 17 clause 5 as well as the notification is not violative of violative of article 14 of the constitution.
Okay, so
Lordship.
you answer one question for that.
Indeed.
Just because you are RBI or very important organ of the government would give you a blanket protection of misusing the data.
Exactly.
Indeed, not, Your Lordships. Your Lordships,
So therefore, 17.5 clearly violates constitution.
Your Lordships, the council would like to cite the case of Kasturi Lal Lakshmi Reddy versus state of Jammu and Kashmir, whereby the honorable court has held that any action taken by the government with a view to giving effect to any one or more directive principle would ordinarily qualify for being regarded as reasonable, Your Lordships.
Stealing people's property is not directive principle.
Your Lordships, the council is humbly trying to establish that right to health or the directive of health is a directive principle under Article 47.
Not you do. Today does not
Your Lordships,
Sir,
it is
you
an
are not in
unfortunate
health
event.
at all. You are a profit-making company in the form of discount.
Your Lordships, it is humbly submitted that
You are not worried about the health of the people.
No, even if I assume that you are giving the medicine at free of cost once you register, you are giving free of cost. I agree. Suppose, still, does it give you a permission to disclose my data to
Obviously
somebody?
not. Obviously not.
Your Lordships, this particular question, Your Lordships, to understand this question, answer this question, section 17 clause 5 is merely regulatory in nature, whereby it's only a conditional delegation that has been given to the central government for the period of 5 years. Your Lordship, the main purpose of this particular
my question
section
is that even giving that conditional permission per se violates my fundamental right.
Your Lordships, the main reason why this particular section was indeed brought into picture was to streamline the process of changing regime, Your Lordships. It's a phased implementation of DPDP Act.
But why should I face the brunt of that 5 years regime you are streamlining?
Your Lordships, such provisions does exist in other legislation also. For example, the Essential Commodities
That
Act.
was the observation by the brother, don't repeat to him.
Your Lordships, Essential Commodities Act under Section 2A provides an exception.
No, brother,
No,
please
that is for
understand,
good. Lordship,
please
it is-
understand,
See,
can
see.
you distribute poison free? And then say, please take it, it will not harm you.
Lordship, but in the instant case, it's definitely not poison,
Ah,
it's
that's
medicine
it.
that we are giving,
That's
Your
it.
Lordships.
That's
We are here
okay.
to protect the lives of the individual, and
Thank
that
you. Your
much
time is
obliged,
up.
Lordship.
Thanks.
Thank you.
It has indeed been an honor to present before.
Yes, please, yes. Yes, yes, go ahead. You have got the onerous responsibility of not answering what your fellow council has not answered. Come to the legal point, as brother said, straight away to the
We
issue.
know the facts, we know I've debated it enough, straight away.
Your Lordships, it is merely to state that the council runs the risk of posing rhetorical arguments before the court, considering the fact that there have been extensive deliberations over the issues that this instant council seeks to address in the arguments, Your Lordships.
All right.
That's fine, that's fine.
Good, good. You had the benefit of hearing us.
Indeed, Your Lordship. Your Lordships, the council would be addressing
You know,
issues 3
you
and 2.
know our mind.
Indeed, absolutely, Your
And the other side case as well.
So, you have
Absolutely.
all the advantage now.
Absolutely, Your Lordships. Your Lordships, the council will be dealing with issue 3 in a fourfold manner. The first limb of arguments pertain to the presumption of constitutionality. The second limb pertains to the fact that there has been good faith. And the third limb pertains to the public welfare objectives or actions which have to be taken by Medicine Co. being an instrumentality of the state central government. And lastly, Lordships, the objectives under the directive principles of state policy, namely under Article 47, Your
Okay,
Lordships.
pause for a moment here.
Indeed, Your Lordship.
Why is the concept of good faith relevant in the context of section 35 read with the object of the statute and my right
Your
as a
Lordship,
consumer?
indeed,
Why
Your Lordship.
am I bothered whether you have acted in good faith or not? I have lost.
Indeed. Your Lordship, under Section 35, since medicine company being an instrumentality of the central government qualifies for such immunity under the instant provision, it does not provide a blanket exemption on whether any action of the medicine company or the central government is liable against, is immune to any such legal action. But for the fact that if there is good faith in the actions of medicine.
No, you didn't understand my question. Let me
Indeed,
put it
Your
again.
Indeed,
There must be a nexus
indeed,
between the statute
indeed,
and the object sought to be
Sought to be
achieved by the
achieved.
statute. Is that correct?
indeed.
Do you agree that if there is no nexus, it is violative of Article 14? Do you agree?
Your
If
Lordship.
there is no nexus between the provision and the object sought to be achieved, then Article 14 is violated. You
In-
agree with that?
Indeed, not, Your Lordships, because the council would like to cite the examples of the Companies Act under Section 456, as well as the Right to Information Act under Section 21, where a similar or a pari materia provision has been provided or enshrined under the respective acts for protections to the government or the entities under the
So
government.
now, because you have raised the RTI, let me give you an answer.
Indeed, Your Lordship.
Suppose a PIO has given an information to somebody which he is not supposed to give, but in
Indeed.
good faith, no much harm is done.
Indeed.
Therefore, he is protected.
Indeed,
But that cannot be looked at. What he is asking, sir is asking you is, you have the object of the act.
indeed.
Now, how good faith is supporting any one of the object of that?
Look at the preamble to the statute.
Indeed. Your Lordship, the council would like to read the preamble verbatim for Your
Yes,
Lordship's
yes,
convenience.
please.
An act to provide for the processing of digital personal data in a manner that recognizes both the right of individuals to protect their personal data and the need to process such personal data for lawful purposes and for matters connected therewith or incidental thereto. Your Lordships, the council would like to clarify that the data has been processed for a lawful purpose under.
No. I'm assuming for the sake of argument that the data has been processed for an unlawful purpose, but bona fide.
Lordship,
Then would you still say 35 is applicable to you?
Lordship, 35 would be applicable for the
So
fact
fine.
that
Therefore,
the.
how does it take the object of the statute forward?
Indeed, Your Lordship. So 35, irrespective of the fact that whether the act is done negligently or not, would apply to companies or the central government in this instant case, Your Lordship. In light of the same submissions, the council would like to quote the provision of Section 3, subsection 22 of the General
Whether your
Clauses Act.
submission is in consonance and corroboration with your written submissions, or is it contradictory?
Indeed, it is in corroboration with the written submissions, Your Lordship.
You
So
want
It
to-
is supporting
you
the
want
written
to-
submission.
You want to reiterate that? Shall I point out?
Lordships, the council will be happy to answer any question, Your Lordship.
Take out your point in the question issue number 3 and then see what written submissions you have made.
Lordship, it is in line with
Read
the.
no, you will understand.
Read which paragraph
I
exactly?
do not know for the issue number 3, you will have to read, no?
Your Lordship, under issue number 3, the council would be submitting in the
No,
following
you said
links.
about 4-prong approach. The third and fourth, you read it. You said it is four-folded.
Indeed.
Third fold and fourth fold, you read, and what you have submitted now.
Your
the
Lordship,
query?
the third fold pertains to the facilitation of public welfare objectives.
Exactly.
And
Now taking away the money, is it a welfare object?
Indeed not, Your Lordships.
Obvious.
That's all.
Obvious. If that is so, why should you have a safe harbor provision?
Your
for
Lordship,
You
benefit?
cannot insulate, sir.
You can't insulate yourself.
Your Lordship, there is no bad faith on the part of medicine.
That is a later point. That is a
assuming
Indeed.
that there is no bad faith, that it is good faith. You also are surprised that there's a data breach. All that is taken for granted.
Indeed.
But why should I suffer?
Your Lordship, the council is
Why
not.
should you get the protection? I should get the protection.
Your Lordship, being the council for the central
That is
government,
the
the council
object.
has
That's
to.
the object.
Your Lordship, being the council for the central government, the council has to defend the arguments of the
No,
central government.
No, please, don't be under that impression.
Indeed.
Any council is equal officer of the court.
Indeed.
The only duty is to put the facts to the best of their ability
Indeed.
and not to advocate illegality. No illegality should be perpetuated.
Indeed.
Now,
Very clear.
I want to ask you, are you appearing for the central government or are you appearing for the company?
Your Lordship,
whom are you
appearing on
appearing?
behalf of the central government with respect to the issues that pertain to the constitutionality.
You are
in
not
this
appearing for the company.
instance. Your Lordship, considering the fact
You
that
are the
medicine
council for companies, sir. Come to the point.
Indeed. Your Lordship,
Then don't argue for central government. Central
Really?
government, we take
Indeed.
them to task.
Indeed, Your Lordship. With respect to Medicine Co, all the actions that have been taken by Medicine Co in ensuring that there have been procedural safeguards with respect to the actions that have been taken by Medicine Co in rendering its service of retailing medicines at a subsidized rate, Your Lordship. For the same, the council would like to establish the procedural safeguard in the fact sheet, Your Lordships.
Yes.
In respect of the same, the council would like to refer to page number 1 of the fact sheet.
Yes.
And in the last point, which talks about automating fraud detection, Your Lordships.
Yes.
So under fraud detection, Safety GPT analyzes customer transactions and flags potentially fraudulent activity based on predetermined criteria.
So therefore, there was no slag in the system. System was foolproof.
System was fine and Medicine Co.
System was foolproof.
Indeed.
So there is an external agency. That external agency is the responsible for the leakage.
Indeed.
Somebody has opened the safe locker.
Indeed.
It is you.
Your Lordship, the liability cannot be imputed on the central government, Your Lordship, because Medicine Co. is
Sir,
in the.
you are not central government. Central government thought that you will save the safe locker
Indeed.
without opening it.
Indeed.
You are the one who committed the breach.
Indeed not, Your Lordship.
Why should that law give a breacher
Your Lordship,
protection?
Your Lordship, Medicine Co. has entrusted Safety GPT in this instant case as a third party
No,
application.
your fact sheet says that it is foolproof, sir. Safety GPT, we have understood. All necessary precautions have been taken by you. When you started the company, it was all in good faith. It all happened in good manner. Everything was all right. I subscribed, I resubscribed, I ordered my medicine, I reordered, and then got the necessary benefit. All that was true, correct?
Indeed.
But for the breach has happened overnight. I have been duped. Therefore, it is what? Showing something and taking away everything.
Indeed not, Your
Very
Lordship.
bona fide.
Your Lordships, the council would like to argue by
So
saying.
therefore, the idea is, see, we only want to understand the purpose of section 35, protection, insulation.
Indeed.
See, we wear the gloves. Gloves are given for an electric lineman. When he goes and operates, he should not get electrocuted, right? Purposefully remove the gloves and then operate. What do you happen? Will the insulation apply to you?
Indeed not, Your Lordship.
You did that.
Lordship, the council begs to differ from this fact by arguing that Medicine Co has acted in the interest of the general public in rendering services which pertain to retail of
Allowing them
medicine.
to lose
By
their money.
taking away their
The-
money.
Your Lordship, that was not the intention of Medicine Co, Your Lordship.
What intention is irrelevant. My right, my money is gone. If a person takes away my money, bona fide, I will still agree, no?
Indeed, Your Lordship, the
So
council.
therefore, what is the remedy?
Your Lordship, the council is happy to pay any compensation which forms a part of a different suit, but for the purpose of the instant suit, the council would like to rely on the constitutionality of the impugned provisions under this particular act, Your Lordships. Obliged, Your Lordships. Further, the council would like to state that as it already argued earlier, the actions of Medicine Co is in furtherance of the public welfare objectives as stated under Article 47 of the Indian Constitution, which is supported by the fact that in Mysore paper mills case, the court emphasized that the importance of protecting state enterprises from performing public functions, it has to be protected from excessive interference, and thereby, Your Lordship, the council would like to bring in the doctrine of chilling effect, whereby
Doctrine of
chilling effect, Your Lordship.
chilling effect.
Indeed.
Who is chilled now?
Your Lordship,
No, please. See, now the argument will be, as we have understood, as you made it, well, factual aspects, you agree that there is a breach and
Indeed.
you would like to compensate. Now,
Absolutely.
the argument will be academic in nature, so far as 35 and 17.5 are concerned.
absolutely.
Well, 35 cannot be taken away for an isolated incident.
Indeed.
For an isolated incident, 35, you may apply it. That I think that's the line of argument.
Indeed.
You may now say 35 is not applicable to me. I am prepared to do it. But as a whole, 35, you don't strike it down.
Doesn't have to be struck down, Your Lordship.
That would.
Indeed.
That's what is that?
Your Lordship, the same rationale or the argument that was propounded by Your Lordship in this instant case was tried to be established by the council, where it is tried to establish that there was no mala fide intention on part of the medicine company to, whereas the intention of medicine company was only to render services at subsidized rates, considering the fact that Indiana is a welfare state and
Your prayer. You want the entire case to be dismissed, not the compensation to be paid.
Your Lordship,
We are very happy. If you agree that you will pay the compensation, we'll fix the compensation and allow the petition holding 35 and 17.5 intact.
Your Lordship, the compensation aspect would form a part of a different suit
Yes.
and not the instant suit, Your Lordships. Obliged. Further, Your Lordships, the council.
Why you say that? Why can't? You think that under 32 we can't?
Indeed not, Your Lordships. The court is entitled to grant damages under the Instant Act, but the issues that have been framed by the Honorable Court pertain to
No,
whether.
under 142, can we give any relief?
Indeed, Your Lordship. The Supreme
Union
Court.
Carbide, look at it.
Indeed.
The trial magistrate could not, in the first instance, grant more than 2,000 rupees as the fine
They
for
were
the
800
offence
crores.
under section
800
304A.
Indeed.
Thereafterwards, you know, what is the
800
amount that the
crores.
Supreme Court fixed?
800.
Indeed.
800 crores.
Indeed, Your Lordship. The council is aware of
But I
that.
still want you to answer, how do you get over the first part of section 35?
Yes, that is still there.
That question remains unanswered. I want you to please answer that question.
First
Uh,
part,
this-
first part of
First
35.
part of 35.
Indeed. The council would like to take reference to the provision, Your Lordship.
Please,
Yeah, go
please,
ahead, go
please,
ahead, go
please.
ahead. In fact, more than 35, I think you should go to section 39. First
Indeed.
part
35,
of
35, first part, read with 39.
39. 39 is
The actual
actual
injunction,
immunity, the actual prohibition against the civil court. Please
Sure.
read that. How do you get over it?
bar of jurisdiction.
What is the remedy?
Your Lordship, in respect of section 39, the council would like to propose that the
39.
39, Your Lordship. In respect of 39, the council would like to propose the doctrine of alternate remedy, which has to be exhausted before any other remedy can be sought before a civil court.
No, sir, no civil
what-
court.
Bar,
No,
sir.
no, what we are saying is,
Indeed.
the act, if you go to the board will impose only penalty,
Indeed, Your Lordship.
correct?
Indeed.
There is no question of compensation.
Indeed.
Under,
Indeed.
so now for the compensation, if they want to move to civil court,
Indeed.
it is prohibited under 30.
Your Lordship,
What is their remedy? That is the question.
What is the remedy? How do you get over? Just look at that one sentence and give us an answer. That's enough for me.
uh,
I have difficulty in understanding that.
Your Lordship, An alternative remedy can be pursued under Articles 226 as well as Article 32 of the Constitution of India, whereby a writ can be filed in respect of damages or compensation that can be claimed in respect of any violation of fundamental right, or where under Article 226 the High Courts have expansive powers to compensate for the remedies as a consequence of breaches.
You are now contradicting yourself. Just now, when my learned brother asked you, can I grant relief of compensation in this proceeding under 142? You said no.
No, indeed not, Your Lordship. The council had argued that remedy can be granted, but for the sake of the instant matter at hand, the issues are confined only to determining whether the issues are
So you mean to say that if the petitioners comes under 226 as a separate suit for damages,
Indeed.
This R32,
Indeed.
that for this court,
Indeed.
you agree that
Pardon, Your Lordship.
do we have
Indeed, Your Lordship. The court has jurisdiction to grant compensation in that respect, Your Lordships.
but they cannot go to civil court.
Your Lordship, since there is an alternative remedy that is available and immunity has to be provided for an entity like Medicine Co, which is performing a function of a public welfare, immunity is to be granted in this instant case.
So 39 is a bar.
39 acts as a bar. Your Lordship, since that section 39 is not in the issue of whether it's constitutional or not, the council would like to confine the issues to section 35, Your Lordship.
Mr. Counsel, please understand, whenever there is a bar in the civil court, bar of the suit in a civil court, the legislation has gone through how the civil court has actually catered to the needs of the persons, and whenever a special enactment is made, they have in their clear mind, with clarity, they have stated that no civil court, because we want a special remedy at the earliest. That is the intention of bar section to be used into, not the way that you are put to remediless. That is the idea which the 39 is to be looked into.
Indeed.
Because we have the DRT Act, similar civil court bar. We have other acts like the Protection of Investors Act.
Indeed.
Those are all the where their civil court is not there.
Indeed.
We wanted something similar section all under one umbrella. If the board was able to cater to that need, probably this 32, we would have said you go to the board.
Indeed, Your Lordship. Lordship, for the Lordship's clarification, the Data Protection Board under the provisions of this Act is deemed to have the powers of a civil court under the Act, Your Lordship. So
We know it, sir.
indeed, Your Lordship.
We
So
know it, sir. Not only civil court, but also the criminal court.
indeed.
But tell me a single case where board has decided came to the rescue of the people like the petitioner.
Your Lordship,
Do you
considering
have any statistics?
Your Lordship, the council is not in
No,
possession of
it
any.
has not worked at all. It is yet to take off. Flight is there, it yet to take off. Shows the capacity.
No, that's under section 27. Does any provision permits the board to grant compensation?
Lordship, the council like to peruse section 20.
Yes.
Please go ahead.
Unless you bring it under, unless your argument is that it comes under 27(2). Any directions.
There also the direction, we should understand that it's a compensation.
Yes. Yes.
So you are giving him a chance.
Yes, we have seen. No, let him say, no.
What is your position? We want to
yeah.
understand your position.
Your Lordship, the council would like to clarify that the council is unable to provide real life instances or quote real life instances.
No, all that brother wanted was, board could have granted some relief in the form of compensation as well. It's not restricted to the penalty alone.
Indeed.
Was what was.
Provision under which board can grant them any compensation.
Your Lordship, the board is entitled to issue directions in the respect of the same, Your Lordship. So
Does that, in the directions includes direction to pay compensation?
indeed, Your Lordship.
That's all. That's all.
That's what
Obliged,
we
Your
want.
Lordship.
Yes.
With that, Your Lordships, considering the paucity of time, the council would like to move to the second issue.
Yes, please.
Yes, go ahead.
The second issue, Your Lordships, pertain to the processing of bank account details. In respect of the same, the council establishes that there is a lawful purpose, necessity, as well as a proportionality in respect of actions of medicine company, Your Lordships. The council would like to also clarify that consent has
2
been.
minutes more.
Indeed, Your Lordship. In this instant case, consent has already been sought by Medicine Co from the data principals or the subscribers of Medicine Company And to substantiate on the same, the council will take your lordship's attention to the appendix 2, your lordships, whereby under clause 8 as well as the payment data clause, there is a clear indication as to the fact that for necessary purposes, payment data is collected and stored.
What is necessary purpose?
Lordship, necessary purpose is to the fact that since medicine
Allow
company,
some third party to take away your money.
indeed not a lordship, since medicine company is rendering an online function, since
Mind you, you will have to answer the question that we have put to him. I remember that question. I'll come back to you for that.
indeed, your lordship.
Because he wanted to escape. You cannot escape.
Indeed, your lordship. Lordship, so citing the clause 8.
No, again appendix 2. Please
Indeed.
tell me,
Indeed.
appendix 2, your fact sheet read together, it's a foolproof. It's a watertight compartment.
Indeed.
Hardly there was any scope for anybody to intervene. That is why it is called safety GPT.
Indeed, your lordship.
Now, where is the safety?
Your lordship, since this case concerns medicine company, since being medicine companies, since
No,
medicine
whatever the company,
Indeed.
safety GPT will act. It will not know whether it's a medicine company or RBI. Please tell me, pilferage of the data, unless an external instrument is involved, because you say safety GPT, we have checked. There was no loophole at all.
Indeed,
It
your
was
lordship.
protected from all angle, and it was by AI.
Indeed.
No other intervention was there. Unless some intervention has happened with the safety GPT, the data could not have happened. Your website, that is appendix 2, never said about this contingency, assuming that you are also duped by that. Where is the protection then? Where is the due diligence?
Lordship, at the time of
Wait. We have put a new question to you.
Your lordship, at the time of entering into the contract or the deal with a safety GPT was the only alternate option available which had the capacity to process huge amounts of personal data. Since medicine company itself cannot be tasked with the fact that such large amounts of data can be processed, which will thereby result in a breach.
You see, Mr. Counsel, when you're looking at the constitutionality of a statute, you cannot restrict it to the facts of the case. Now, let us assume that I have given my prescription to you.
Indeed.
Now, my prescription, there is a data breach and you disclose my prescription to all and sundry. I'm very upset about it, that everybody knows about my ailment.
Check.
Indeed.
Why should it be done? Why should we allow it?
Your lordship,
You forget about all this money breach and all that. There's one instance. Now, why should my private information
Right to
about the
dignity.
medication?
Right to dignity.
indeed,
More
indeed, your
so
lordship.
when you are dealing with the medicines.
Medicines. Why should anybody know
Indeed.
about my ailments?
Indeed, the council accepts that, your lordship, but in counter, the council.
In fact, legislations are there. The data with regard to the HIV positive should be stored confidentially.
Exactly.
Indeed.
We cannot address also.
Indeed.
Even when they appear before the court, their identity should be masked.
Indeed.
That is the way, that is the stage up to which the courts have gone in protecting the personal dignity. Article 21 may not contain all these words,
Doesn't matter.
but we have read into Article 21 these aspects. When constitutionality is involved in a particular provision, Article 21 will definitely creep in every time and then say, I am here. Look at me and then pass orders. Look at me and then pass orders. Before striking down any provision in the Constitution or any other statute, please look at Article 21 again, and then take a call. Be slow. Article 21 is guiding me. Article 21 is protecting me. So you'll have to cross that barrier. Where is that? Nothing is there.
Your lordship, the council begs to differ by saying that as an alternative.
Article 21 should not be looked
No,
into.
no, not that particular argument, your lordship. The council begs to differ by saying that major pay as an alternative was already provided for the convenience of the data principles, whereby sensitive information like bank account details was not required for the
It is
purpose
you,
of.
sir. Major pay doesn't have a direct access. He gets the data which you collected, stores it, and then
Indeed.
whenever a payment is
Indeed
to
not,
be
your
made,
lordship.
that will be looked into.
Indeed not, your lordship, because
It is. Primary data is taken by you and stored by you.
Indeed not, your lordship,
By
because
agents.
medicine company had a two-way subscription method, whereby one way was
No,
to.
we have asked that question to them also. We are not concerned with the people who have booked from the app.
The question is the debt of bank is collected by whom? Is medicine company or the major pay?
Your Lordship, medicine company collected and it was given for further processing to safety GPT, Your
You
Lordship, which,
should not have given is our answer.
Your Lordship, there was an element of voluntary consent or choice which was provided to the
No
data.
consent, no consent. Implied consent is not a consent. That's what Putswami would say.
Indeed not, Your Lordships, because there was an option which was
You have
provided.
duped me, therefore you cannot take that advantage, you cannot take that insulation. You have removed your gloves and then tried to touch 440 volts.
I will even dilute that question. I won't even use the word duped. You have deprived me of my money.
Exactly.
Enough.
Your Lordship,
I mean, I don't care whether you did it bona fide, honestly, whatever you did. I lost my money.
Your Lordship, at the time of entering the
Why
particular.
why give you protection?
Lordship, since considering the data as a touchy subject, which is still subject to scrutiny, and there is no, and the legislative framework is still being tested, the medicine company cannot be attributed with all the only the reasonable safeguards can be taken in respect of the same, in consideration of the fact that data is still evolving, Your Lordship. So, medicine company, in the interests of its data principles, has taken all efforts to ensure that data is not prone to spillage or breach, Your Lordships, by ensuring that there are procedural safeguards and the fact that there are alternatives provided to the data principles to
Is
enable
there a
the member.
disclaimer clause?
Your Lordship,
Is there a disclaimer clause?
Your Lordship, the disclaimer.
Is there a disclaimer clause in your website? If
Lordship-
it is so, yes, you are entitled to take that insulation.
Uh,
Knowing fully, I would have entered into a contract, maybe it's a unilateral. Still, it is valid, provided there is a disclaimer clause.
In fact, for the same reason that I'm telling you, I would strike down section 7.
Your Lordship,
Look at what section 7. Give a protection on the one hand, take it away by the other. What kind of a law is
Or
this?
nullify.
Nullify.
Your Lordship,
Nullify the protection.
For the same, the council would like to argue that medicine company performing a function of public importance, an effect of chilling effect would be passed on to medicine company, whereby due to the fear of litigation and to the fact that each time consent has to be obtained when a function of public importance is performed, it would render the process too tedious to.
Correct, sir. Then amend Article 21 and exclude privacy from the ambit of Article 21. And then we'll test the amendment on the basis of basic structure.
Your Lordship, the council would like to conclude.
Okay, go ahead.
Lordship, the council would like to move to the prayer, Your Lordship, considering.
We know the
Please
prayer.
don't-
We know the
please
prayer.
please
You are
don't
saying
go to
uphold the
prayer.
statute.
You want the dismissal.
Uphold the statute.
Indeed, Your
And
Lordship.
dismiss the petition.
So thereby the council would like to end the submissions. It was an honor arguing before the court.
Yes.
Thank you,
Obliged.
thank you.
Any rebuttal?
Any rebuttal? Go ahead, go ahead.
Can I?
The council takes permission to continue.
Go ahead, go
Yeah,
ahead.
yeah,
Right.
You have done extremely well. Go ahead. We're looking forward to hearing you.
As per section 8, subsection 5, data fiduciary shall protect even if first processed on its behalf, even if you process data on its behalf. Therefore, you cannot claim the liability and shift the liability
Here,
on
here,
safety GPT.
Here, arguments are to here.
Certainly,
Not there,
Lordship.
not defense, for
Certainly,
granting the
Lordship.
relief.
Secondly, that they learned friend stated that they took explicit consent, but Mr. Aditya's statement stated otherwise. They stated that there is no requirement of explicit consent, Your Lordship, that goes against my learned friend had stated. Next, petitioners have argued that immunity is granted to both center and state. Medicine company, however, in the present case, petitioners have argued as to why medicine company must be granted immunity and conveniently ignored that why state central government is also not granted immunity under section 35. Lordship, next is the response
No,
that failed to prove that.
The idea was, I'm equal to central government was what was the argument. Argument it did not follow. The protection, immunity to a central government is the same insulation coat I am wearing. That is the argument.
Certainly, Lordship. Next is respondent that failed to prove that how does taking bank account details is not used for commercial intent and only for welfare purpose, Your Lordship. And even they've stated a lawful purpose under section 4 defined has been clearly laid down. But Lordship, in the BR Shrikrishna report which they have stated, it is also mentioned that there are more than approx 21 laws which goes against each other. Then which law would they say that it would be lawful in nature if laws goes against each other? Lordship, the next is saying and collecting data for business purposes. They collected data goes against the principle which they already stated that it is only for welfare purpose. Because when they're stating that it is for business purpose, they are collecting data.
I just
It
want to
is
ask
not
one
welfare in
question of you.
nature.
Do you admit or do you dispute that this company is engaged in welfare measures?
I dispute the fact, Lordship. And lastly, Lordship, I would like to contend that they have stated they have adequate mechanism. Now, Lordship, when they stated they have adequate mechanism, at the same time when they're shifting the liability, they're taking all the exemptions, and also there's no even as per they have stated in their memorandum that auditing mechanism is there. Auditing is only for significant data fiduciary, and as per the laws, no significant data fiduciary has been established by the current act. It has been for even if rules had been levied down, then only significant data fiduciary should be there. And as per SPDI rules, Your Lordship, there had to be reasonable mechanism and the procedure levied down. And herein, though no legal mechanism is there. So as per if central government frames any mechanism at hand, that would become reasonable in nature, which goes against the very objective of this law, that is to even process the data for lawful means and also to protect the data. Lordship, I rest my submissions.
Yes, please.
Any survey button?
It's my honor to appear before its honorable court.
Yes, thank you. Thank you.
Lordships, the council would like to place threefold rebuttal to the rebuttal that's made placed by the council, Lordships. Firstly, with regards to whether
Only with regard to.
only with regards to, I won't venture anything further because
Don't
I am afraid of questions, Your Lordships. Your Lordships, with regards to whether Medico in the instant case is a welfare organization or not, Your Lordships, the council would like to state just because there is an element of commerciality attached to Medico doesn't mean that it cannot be stated that there is no welfare attached to it. Similar to the instance of IRCTC. Indeed,
They
Your
agreed
Lordship.
that it's welfare.
Much
No, they
obliged.
disputed it.
They disputed.
She
They
said,
agreed for the welfare of the company.
Your Lordships, with regards to the mentioning of SPDI rules of 2011, Your Lordships, the council would like to take reference to section 44 of the DPDP Act, whereby section 43A of the IT Act, as well as section 87 clause 2 has been omitted from IT Act, Your Lordships, by the DPDP Act 2022, Your Lordships. Your Lordships, these are the provision which gave effects to the SDBI rule of 2011. And therefore, for the same reason, since the regime has changed to DPDP Act, whereby the personal data has been streamlined into one particular legislation in itself, this particular rules, SDBI rules, stands invalid, Your Lordships. And finally, Your Lordships, the council would like to take Your Lordships' attention to page number 8 of the compendium, whereby portion of the Honorable the Justice K.S. Puttaswamy's Union of India has been produced. Reading paragraph number 292 of the said judgment, Your Lordships, in dealing with a substantive challenge to a law on the grounds that it violates the fundamental right, there are settled principle of constitutional interpretation, which, Your Lordships, page number 7, Your Lordships.
Yes, go ahead.
In dealing with a substantive challenge to a law on the grounds that it violates a fundamental right, there are settled principle of constitutional interpretation which holds in the field. The first is the presumption of constitutionality, which is based on the foundational principle that legislation which is entrusted with the duty of lawmaking best understands the needs of the society and would not readily be assumed to have transgressed the constitutional limitation. The burden lies on the individual who asserts a constitutional transgression to establish it. Secondly,
That was the opinion of the bench. Leave
indeed,
it
Your
at that
Lordships.
now.
Lordships, secondly, the court treads warily in matters of social and economic policy, where they singularly lack expertise to make evaluation.
Understanding of the needs of the society is to steal people's money.
Your Lordship, the understanding of the needs of the society is to provide affordable healthcare provisions to the citizen. Your Lordships, though the facts of the merits of the case might seem against the respondent in an instant case, the counsel of the respondent come with two hands together to pray before this honorable court that it's indeed not unconstitutional. The provision of the section is not unconstitutional. Even if there's a singular event of violation of data breach in an instant case, the counsel pleads before this honorable court that separate proceedings may be initiated against respondent where we pay compensation, Your Lordships. With this, the counsel would like to rest the sir rebuttal, Lordships. Much obliged.
Thank you.
Thank you.
Thank you.
Why not? Yeah.
Yeah, sure.
Reassemble.
The judges will now be escorted for scoring.
This is all this I don't read. This is enough.
Everyone kindly reassemble in another 10 to 15 minutes.
No, I don't read.
Everyone